Ms. Holmes, you're working on George still? Christina George?
Christina George.
But it has charges that have not been indicted, but she has.
Okay, pause right here. Notice the legal juggling act? The judge is pointing out that some charges haven't been formally indicted, yet another charge is already moving forward. This matters because in criminal law, an indictment is the formal step that locks the case in for trial. Without it, those other charges are just floating in limbo. Ever wonder how many cases stall out like this before they even hit a jury?
It works out with Mr. Smith and with
What can I do?
what can, all right. So we'll go ahead and reset Mr. Bell then off that trial docket. Not off the trial docket, to the next trial. So on
Smart move by the judge. By asking for an amended motion to include the new indictment, she's essentially cleaning house. Think of it like updating your software. You want all the latest charges patched into one motion so the defense can't later argue, hey, you forgot this one. It keeps the process airtight.
County, and they stated that they, as of June 30th, had not filed anything further pending, which you can read either there's nothing pending or there's only one thing pending. So it's a drug case. So I don't know if they're saying, well, it's not pending because we don't have a lab back.
but you think it's been indicted now?
Yeah, she said in the email, she said there's one, she was indicted on March 27th for a second-degree felony possession. That it was set for court in July, but that offense differs from the offenses listed in the MTRP.
Okay.
So the offenses on the MTRP have not been filed.
But there is one that
But
has.
there was one that was indicted in March.
Okay. I feel
That
like
makes sense because the ones in the MTRP are from 2004 and the March is
24.
2025. But
Yeah.
sorry.
so. What let's just do. I'm gonna reset it one time, Ms. Malfino. If y'all will get an amendment done, just so that when there's pleas of trues or not true, it's to everything that's out there, and there's not any question. I mean, if the other ones aren't coming that are old from 2024, that's fine. But if we've got one indicted, let's go ahead and get it in the motion.
And I know last time she had been hesitant to go to treatment. I will reach out to them and ask if that's something that is ordered, that would concurrently take care of
that.
cases
Okay,
as well.
that would be great. Thank you. All right, we'll get all that tried to, so everything kind of happens at one time, hopefully. Okay? All right, go back with the bailiff, please. Ms. Perazzo, you've got Avion Johnson. It's a sentencing hearing. Good morning. How are you?
Good, how are you?
Oh, it feels like a Monday times 10 on a Tuesday.
Yeah.
Monday, I'm 3 people today, and son decided he needed to pick up the pit bull puppy on the side of the road so it didn't get run over yesterday, and I've been up all night.
Oh, and they cry like babies. I've raised two.
All right, sir, are you Avion Johnson? And this is 24 DCCR 2044. Mr. Johnson was previously in court, entered a plea of guilty to the offense of arson, intending to damage a habitation or place of worship. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
So no corrections, but there is an issue. Ms. Malfino and I have spoken about this. On page 2, at the very top where it says restitution issues, it looks like there's an outstanding bill, if you will, for repairs in the amount of $150,000, but
Whoa, did you catch that? Johnson says, I wouldn't say I did it, but I contributed to it. That's not a guilty plea. That's hedging. In courtroom terms, this is dangerous. If you claim it was an accident, that undercuts the entire guilty plea. The judge immediately calls it out because once you plead guilty, you can't later spin it as a misunderstanding. That's why plea bargains are a legal tightrope.
Him very well, actually, and he didn't understand some of the predicament I was in with respect to the complainant, that I had let the court know in advance about her mental status and cognitive ability to testify, etc. If you would like me to take a deeper dive into where that restitution is owed, if any, that's obviously way substantial amount to order Mr. Johnson. I am concerned about his behavior.
Well,
while awaiting
I'm
sentencing.
concerned about his behavior, but I'm just as concerned about the fact that he denied the offense.
Right.
Yes.
So if you didn't do it, then you shouldn't have pled guilty. And so that's what a jury's for, to come in and decide if you are guilty or not. This says, at least what they put in here, that you said that there was a bottle of lighter fluid on the floor, that she flicked a cigarette and the fire just started, which is different than that's obviously not arson, that's an accident. And so we've got to get past that before we do anything else. So either you did what they charged you with, which is starting it in anger or whatever else was going on, or not. So did you do it? Did you not do it?
No, I wouldn't say I did it, but I would say that contributed it to it. We were kind of wrestling, and it just happened.
Again, that sounds like an accident, not arson. Because here's the thing. I mean, a 5-year deferred probation is a great deal. I mean, you don't have, well, I say that. You do have criminal.
And here's where money comes in. Restitution is basically the court saying you broke it, you bought it. But $150,000? Even the lawyers admit that number might be inflated. Instead of wasting weeks fighting over it, the judge cleverly sets a not-to-exceed amount. It's like giving a credit limit. The real figure will get hammered out later. Efficient, but with huge financial stakes for Johnson.
You know, when you were here before, you were standing in front, you stood in front of the clerk, you took an oath, you said you're going to tell the truth. And so telling the truth is either accepting responsibility if you did it, or saying it was an accident. And if it was an accident, it's an accident.
But I played out to it, I played guilty to it, and I accepted the charge for arson. I understood what I was saying, so.
Okay, all that's great. Did you do all of that because you're guilty of the offense?
Yes, ma'am.
Okay, so I guess what we need to do at that point, then I don't mind. The only problem is I need to have that restitution before sentencing.
Yes, ma'am.
But I don't want him, if he's getting a deferred, he didn't need to be sitting in jail.
An idea might be, if I may, Judge, to order not to exceed that amount. I will confirm, and then we can
Sure.
drop it to.
Yeah, that's probably the easier way to go ahead and get it sentenced so you can get out. Obviously, I wouldn't expect that it would be anywhere near that, though. I mean, that would.
If you understand my position of
Sure,
what I'm saying
absolutely.
about where
I
it
do.
was.
Yeah, and then if you, if there's an issue when the restitution amount, if any, comes out, and we need to have some type of hearing on that, then we can still do that even though he's sentenced, if I do a not to exceed amount.
Yes, ma'am.
So do you understand, Mr. Johnson? What I'm going to do is go ahead and give you the probation today. I'm going to order restitution not to exceed $150,000. No one expects, I don't think, for it to be that, or maybe who knows what, maybe not anything, maybe much lower than that, depending on insurance and whatever else. If there's an issue with that, we can handle it later, but that way we can get you sentenced today and you can go ahead and be released. Do you understand? Now, if there is restitution, and you will be required to pay it on that probation, so it's really important that if there is any ordered, that you start making payments on whatever it is. every single month, even if it's just a little bit, to show me that you're making those payments, okay? So what I'm gonna do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Defer all proceedings for a period of 5 years. There will not be a fine in your case. There will be restitution ordered in the amount of not to exceed $150,000. Now, I have a note here that if I accept this agreement, there might be something else I do because of your jail incident reports. You know, I mean, you were just in a fight in July out there. June, talking disrespectfully to, I'm not real sure what's going on in the jail to make any of you that are sitting in jail thinking that the correctional officers are going to somehow have anything to do with you when you get out of jail. I mean, really? You think that's where you're going to meet your next girlfriend?
No.
Then you shouldn't be talking to them like that, right? I mean, you threatened one male officer that you were going to beat his ass.
Say something a little bit.
I don't know. You probably shouldn't. How old are you?
I'm gonna get 32 in December.
You're too old to be acting like this. This is the kind of stuff I'm getting on the little young punks out there. You know who I'm talking about. All of them that are out there acting like heathens. That shouldn't be you. You're not doing near as much as all them, but I shouldn't be having this on somebody that's in their 30s. I mean, you've already been on probation and know what it takes to be on probation and didn't do it. So I hope that by going forward today, you understand, just like I said, if you follow all of the rules of this probation, great opportunity, right? You don't have this conviction on your record, you get out, you live it like the rest of us. If you violate any condition of probation, you're brought back into court, you become a convicted felon on this case, and I have the whole range of punishment, which is 5 to 99 or life. And I'm going to look back at that time and see that I gave you an opportunity on probation when you just revoked a probation 2 years ago. And so it's probably not going to be some little mountain prison and you just get to go on your way. It's going to be, you need to start learning from your mistakes kind of thing, right? Make sense? All right. So I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. Probation will give you some information today before you leave. Make sure as soon as you get out, first thing you do is go to probation, okay? All right, good luck.
Thank you, Judge.
Thank you. So many lectures that don't matter today. Okay, Mr. Cashin and Mr. Johns on Larry Williams.